All right, so Rachel Smith joining me now. Rachel, what questions do you hope are answered in this trial? Do you have any?
I think I think everybody's got a lot of questions that we would like to have answered in this trial. I really think for me, I would love to see more information about exactly the planning that Lori and Alex did throughout, but especially targeting Charles, which is very different and wasn't the evidence offered in the Idaho cases. So I think we'll see some more evidence, more about Alex in the Vallow case and even in the Daybell case in Idaho. There was discussion of Alex, but not a lot. I think this time we'll see much more about that relationship, that conversation between Lori and Alex, because that's part and parcel of Lori's conspiracy to kill Charles.
In Idaho, were you all somewhat limited on what you could bring in as far as the Arizona connection, or was it free reign?
We were limited, but we got in what we needed. And it's something called 404B, evidence of other crimes for some states. Same thing. Uh, you're only allowed to bring in evidence of unconvicted conduct or even convicted conduct if you can show the court that information is directly related to your case and the value to the jury is greater than the harm it can do. So we were limited. We got in what we needed to get in. We had the early hearing. The judge made the rulings. So a lot of the Arizona evidence that Trina Kay and the Maricopa County prosecutors have probably won't have been heard before, at least in court.
Interesting. And I mean, the 404B, you mentioned that during Lori Vallow's Idaho trial, Jim Archibald repeatedly objected to that
Mhm.
because they obviously didn't want that brought in.
Yeah, there had been a motion filed in Lori Vallow's Idaho case and in Chad Daybell's case to admit the 404B. And that was one of those many hearings that were held outside the presence of the public and the jury, to people's frustration, I think. But the 404B hearings typically happen outside the presence of other people because if the court says it doesn't come in, then he hasn't now publicized it. So there was a hearing ahead of time. It was probably a good day, maybe three-quarters of a day, going over the evidence that we would be allowed in from Arizona into the Daybell case and into the Vallow case. So uh, some of the evidence we wanted in wasn't allowed in, not a lot, but in this case, you're going to hear some of the evidence we wanted in that the court said was just not necessary in Idaho.
Oh, interesting. Yeah,
Mhm.
that's the type of hearing I would have loved to be in
Mhm. Yeah,
for all
yeah,
that.
yeah,
Okay, I want to talk about the prosecution's job in this particular case because Lori Vallow Daybell is representing herself.
yeah.
How does that change the game for a prosecutor?
Uh, Pro se cases are a prosecutor's worst nightmare. And I think that's counterintuitive sometimes to the public, but as a
You think it'd be a
prosecutor,
walk in the park because they don't know what
yeah,
they're doing.
yeah, you think it is, but in reality, the appellate courts view it much more strictly. You want to make sure the jury doesn't think you're beating up on somebody. There's a natural sympathy, at least initially. I think Lori will wear that out pretty quickly with this jury, but there is a natural sympathy that goes on in a courtroom in front of a judge where the person's pro se. So the prosecutor has to walk that fine line between being a zealous and tough advocate and always appearing fair and always making sure that they are showing how balanced and even-handed. It's a little different handling objections when you've got opposing counsel. When you've got a pro se person who doesn't know how to do it, you have to be real careful on how you handle it. And trials always take longer. So in this case, you got an extremely experienced, highly competent prosecutor, a very experienced judge. And I think you're going to see a lot of patience and a lot of deference being shown Lori Vallow. And that's to protect the record because the goal is to convict her and convict her once.
Fascinating. So you're saying that when the prosecutor has to decide whether to object or not on certain things that Lori Daybell might question or oppose. I mean, how do you weigh that when in the back of your mind you clearly know she's going against the rules? Is it pick your battles, just kind of let it go, a mix of both?
Yeah, when a pro se defendant objects, I always just sit back and say, okay, is this really hurting me? Which is hard to suppress because most prosecutors are rule followers. And when it violates the rules, it bothers you. It's kind of like a situation where you just know it's wrong, but you have to let more go than you would normally let go. And you only do it if you think it's hurting you or if it's so egregious it could cause a reversal.
Have you ever seen a pro se defendant win?
I have not. I have not. What I have seen is courts of appeals scrutinize the trial judges very closely.
Mm.
This judge is a very experienced judge. The Maricopa team knows what they're doing. I think it may be frustrating to observers and listeners because it's going to feel like Lori's getting away with stuff. But it's really just people dotting their I's, crossing their T's, and making sure that there's no reason to send this back.
So for those of us watching, those viewers over the next few weeks that are like, why doesn't the judge get her in line? Why does he allow that? You're saying he really wants to protect himself and be careful as well.
Yeah, the court will work hard to protect the record, protect any outcome on the case, and that means they're going to show Lori a lot of patience.
Lori Vallow listed me on her witness list, and a lot of people have asked me the question, so can any defendant list anyone on their witness list just to simply keep them from attending their trials?
And they can, and defense attorneys do that as well. Oftentimes, that's a tactic used to try to keep certain people out of the courtroom. In some states, they'll even put victims or their families on the list to try to make sure that they aren't in the courtroom. What recourse the witness or the other side has is to file a motion with the court and ask for either a public hearing or an in-camera conversation. Like Lori can go back into chambers with the judge and say, this specific thing I intend to try to elicit. And if they can satisfy the judge, then the witness is out of luck. If they can't satisfy the judge, then the person is allowed in the courtroom.
When you say in camera, I want to be sure our audience understands because we've heard that term and people assume it means with a camera in the courtroom, but it doesn't really have anything to do with a camera.
No, it's that old English or Latin term, it meaning focused in private with the judge. So the person or their attorney will go into chambers, the judge will question them, or they'll make a statement, sometimes called an offer of proof. It's on the record, but the other side isn't in the room. And this way they don't have to reveal a trial strategy, but they do have to justify their actions to the court. So it wouldn't be atypical for a judge to require the person to come in.
Okay, so the people on the witness list, really it's up to the defendant to say this is why I may need them if the people on the witness list want to attend the trial or watch the trial. But I would imagine most of them just say, I'm not going to bother.
A lot of them say, or they don't have the means to fight it. Some witnesses just can't. Others are like, well, I didn't want to be there anyway. So sometimes they just throw in the towel and move and try to make sure that they can be available to testify and then come in later.
Have you ever seen a defendant list a journalist on their list?
Yes, actually, there was a journalist in Missouri who interviewed a defendant before a trial. He gave statements to the journalist, and then the journalist, of course, published some of that stuff and then withheld some of the statements, saying he would publish it after the trial by agreement with the defense. Well, the court allowed the prosecutor to subpoena the journalist, and the journalist had to turn over their notes, and the Supreme Court upheld it. So I have seen that happen, and it's usually when the belief is that a journalist has some sort of inside scoop.
Interesting. So, if you were on this prosecution team, and I know that's a big if to say because you don't know all the ins and outs and everything, but would there be a theme that you would come up with or some sort of message that you would constantly try to get in the minds of the jurors?
Yes, I would really focus the case on Charles and who was lost, that Lori's desire for money and glamour, such as it was through her new boyfriend, Chad, the author, cost Charles Vallow his life. And so the case rightfully will be focused on evidence in Arizona. In this case, I'd keep it narrow and keep it focused on Charles.
How much stuff from Idaho do you think will be brought in about the deaths of JJ and Tylee? The judge has already said he's going to put their names on the jury questionnaire. But will we hear a lot about the children's death and the horrible manner in which they were found, or is a lot of that going to be limited?
I think looking at the witness list that the prosecution put forward, you don't see a lot of you don't see the people from Idaho. You don't see the people on the list that would be the way to introduce that evidence. So I think we're going to have a very limited trial. There will clearly be some mention of it. There will clearly be some conversation about the scope of the conspiracy. But it is possible the judge will limit the vast majority of it because Charles' death occurred first, and the argument may be the evidence of the children is and Tammy is too prejudicial and not as probative as necessary. I suspect we'll see a very narrow trial given this witness list that was filed by the state.
What did you think of Lori's interview on Dateline?
Oh, Lori is that interview on Dateline was what I was secretly hoping would happen if she testified in her own defense in front of in Idaho.
In Idaho.
Yeah, we had talked about having Rob Wood do the cross because that's at least looking at all the videos, paying attention to the witness statements, seeing how she interacted with law enforcement consistently. That is what she did. She tried to flirt or charm or maneuver her way around the situation, and we were secretly hoping that's what would have happened in her trial in Boise.
And that's why you thought Rob can do it to see if she kind of goes back and forth with him versus a woman.
Yeah, yeah, and there was also Rob just being of the same faith. There was some evidence based on her jail calls that she saw a special connection with Rob, which kind of you saw come out in some of the early motions filed by Mark Means. So Lori's connection and interaction with men is starkly different than her interaction with women. So that Dateline interview was what we were secretly hoping would try to happen in Boise had she testified.
And she specifically requested Keith Morrison. She
Yeah.
wanted on the number one crime program, and she wanted him. Was any of her behavior surprising to you at all?
No, no. It really wasn't. What was surprising was how patient Keith Morrison was, because that would be extremely hard, knowing he followed it the entire time, like you, uh, even before the children were even known to be dead. I can't imagine having to show that level of patience, but he did, and that behavior is what we really thought we would see out of Lori
Hmm.
had she testified.
And do you think we'll see that behavior all throughout the next month and a half, if that's how long the trial goes?
Yeah, we do because there were times during jury selection we could tell there were certain men she really wanted on that jury. And so it was just the way she behaved. I think you will see some of that. What will be interesting, and hopefully you'll be able to be in there and watch, and so you can tell us. She will to see if she'll try to look at the guys and make eye contact and make connection. I don't think she'll be obviously flirty right away, but I will be fascinated to hear from you whether she follows through with that sort of pattern of behavior.
Yeah, I'll have to, pay close attention because we'll obviously be hearing from her, I would imagine, versus, in jury selection in Idaho, it was mainly her attorneys we heard from. In fact, one of the jurors I spoke with after the fact who made it on the jury said she walked in the courtroom and thought Lori was one of the attorneys. She was dressed nice. She was there consulting back and forth with Jim and John. And then she realized on the first day of the trial, no, that's the defendant herself.
Wow. Wow.
So now that you've been it's been 2 years, believe it or not, since that April 2023 trial with Lori. Has anything in your mind changed or stuck out to you as far as, what you experienced that whole time?
Oh, for me personally or
Yeah.
for
Yeah, you
cases?
personally, or the case.
Um, I've tried a lot of cases. Handled a lot of homicides. This one has stuck with me in a way, and putting aside the media, because I haven't really been part of all of that. I've done a couple interviews with you and I answered questions for a couple people, but I haven't really lived with it probably the way Rob and Lindsay and Spencer and Tanya have locally. But for me, it's there will be times I will think about the case, or I received one of the wristbands, the remembrance bands from Kay and Larry, and I'll see that it's in my car, and I'll see that, and I think of them, and it sticks with me in a way that other cases haven't. The depravity of what a mom can do to her kids just really resonates. I'm not sure when that will go away. My daughter was about the same age as Tylee, so I can remember during going over and doing Dr. Christensen's testimony, and in the middle of it, I for whatever reason, I thought of my daughter. So that when you're a mom, when your kids are about the same age, that stuff just sticks with you.
Right. Do you have anything you wish you would have presented at the trial, or anything you wish you could have gotten in?
I would have liked to have gotten in more about Charles. Um, I would have loved to have gotten in, but the judge absolutely made the right call. Would have loved to have gotten in some of her footage where she wasn't, where she was manipulating the police during the request for a psych eval. But in the end, it was Judge Boyce did a phenomenal job. It's one less issue that could, although she's waived appeals, that could have been raised on appeal. So the judge made the right call, but I would have loved to see that. I'll be hoping to see that in this trial. I think there's every reason for it to come in, and I would be very interested to see the jury's reaction to it.
I know a lot of us in the public say, "Oh, we wish we would have heard more of those jailhouse calls between her and Chad,"
Yeah,
or things like that. Which I don't know how many of those. It appears the relevant ones were used, but and you
yeah.
probably could have played those all day, every day, but to no point.
Right. Right. Well, and you had to be careful in both trials because this was really a team effort by Chad and Lori. They really, to me, they mutually manipulated each other and mutually manipulated others. So playing too many of those phone calls, while interesting, you risk the idea that they would see some sort of power dynamic by Chad against Lori or Lori against Chad. Candidly, I was surprised that the defense didn't use some of them.
Oh,
So I was surprised that the defense didn't use more of some of those calls between Chad and Lori to make it look like Lori just, was manipulated by Chad.